This is a video about property recording acts. It's going to cover the purpose of the recording system and also discuss how the different kinds of recording acts operate with a particular focus on notice and race notice statutes. So let's start with the idea of title recording. What is it that we hope to gain out of a recording system? And the answer is lots of things. We want people to feel safe buying and selling land and related interests. But without the recording acts, suppose you're looking to buy, but say you're from out of town and you don't know the seller, you don't know the area. How do you trust that the person selling to you has good title, that they actually own the land that they're selling? Of course, just taking their word for it might be risky. Maybe you can do independent research, but that might be costly. And could you rely on it in any case? But suppose you trust that the seller actually owns the land that they're selling. But then how can you be sure that they would give you clean title? That is, how do you know they didn't already sell the land to someone else? Or maybe that they didn't already grant someone else an interest in the land that would be contrary to your ability to get full use out of the land. Suppose, for example, they gave an easement to someone else that would have allowed them to use a path on the land. Or how do you know there's no mortgage on the land? Likewise, if a bank is financing your purchase and using the land as collateral, how is the bank supposed to be sure that its interest is protected? Enter the recording acts. The title recording system is there to provide that kind of certainty. Title recording protects innocent purchasers from hidden, that is, unrecorded interests, like the possibility that the seller has already sold the land to someone else. Title recording also protects the interests of the people who record them. So if you do buy the land and you record your interest, you are secure from the possibility that your seller will sell to someone else and that purchaser will claim to be a purchaser of the land. And of course, title recording also makes things easier for courts to resolve conflicting land claims. It's easier to look at what's in the records versus engaging in complicated factual analyses of what happened when. Note the flip side of this, though. Protecting the interests of those who record may mean extinguishing the interests of those who don't. This means creating exceptions to traditional common law property understandings of first in time, first in right, and nemo dat, the idea that you can't give what you don't have. So suppose, for example, that O sells a farm to A, but A does not take possession of the property and does not record A's title. O then sells the same farm to B, who checks the title records and doesn't know about A before making the purchase, and then B records after the sale. So from one point of view, O shouldn't have anything to give B once O makes the sale to A. And A was the first to get the interest from O. But the recording acts create an exception to this principle. They would protect B in this situation and extinguish A's interest. And we think this is fair, or property law assumes this is fair, because if B does the research and is innocent and relies on the records, we are willing to favor B over A, even though A was first and A was also an innocent. And note, of course, that A could have protected A's rights by doing what B did, record the title and give notice to the world. Now, obviously, there are trade-offs here between getting certainty, clarity, and general considerations of fairness, and the recording acts draw these lines in various places. So, for example, suppose O conveys land to A, who does not record the deed. O then conveys to B, a good faith purchaser, who does not record. Then suppose A records, and followed by that, B records. So who wins under the common law? Well, under the common law, A would win because A is first in time, and once O conveys title, O has nothing left to give B. Now, how might the Recording Act change things? And so even if we decide we're going to use a recording statute, we can see competing considerations in place. On the one hand, when B made B's purchase, B didn't have any notice of A's unrecorded interest. On the other hand, A recorded first. And so the kind of recording act in place is going to determine whether A or B wins. So let's move on to this question and discuss the kinds of recording statutes that are out there and how they affect which purchasers get protection. So always remember, if a recording act doesn't apply, then ordinary first-in-time principles apply, ordinary nemo dat principles apply. And so when doing a recording act problem, it's sometimes helpful to ask who is it that needs the recording statute? And we'll see some examples of that as we work through the problems. So let's talk about the different kinds of statutes. The first one I'm going to discuss is one that we're not going to deal with beyond this particular mention, and that is a so-called race statute. And a race statute is very simple, but they're also very rare in the United States. The basic idea is that whoever records first prevails, and that's that. So suppose O conveys to A, who does not record. O conveys to B for valuable consideration. B knows that O had conveyed to A already, but B still records first. That is, B has won the, if you will, race to record, and under a race statute, B would win. Now, these are rare because although they offer evidentiary simplicity, they might reward bad conduct. And so the recording acts in most jurisdictions require good faith on the part of the purchaser in order to receive protection. So that takes us to notice statutes. Notice statutes protect subsequent bona fide purchasers for value who do not have notice of a prior conveyance. So O conveys to A, who does not record. O then conveys to B for valuable consideration. B has no notice of the conveyance to A. A then records. Who wins? Under a notice statute, B prevails over A, even if A records first, because the key fact under a notice statute is that B was a good faith purchaser without notice. And so we see that the notice statute encourages prompt recording, because, of course, if A had just recorded upon getting the deed from O, then B would have had notice, because if B had done a title search, B would have found A's deed. And so even if B wouldn't have actually literally known about it, we would say that B would have constructive notice by virtue of A's recording. But of course, in this hypothetical, A did not record and B did not have notice, therefore B receives protection under the recording statute. Let's complicate this a little bit. What happens if C makes a purchase from B? C would be able to find A's recording. And so does that mean C would be unable to get good title from B? And the answer to that question is no. C is able to get good title from B, and C will prevail over A under what is sometimes called the shelter rule. And the basic idea is that the person who takes from someone who is protected by the recording acts gets the rights of the grantor. And so here, that would give B the benefit of B's bargain. That is, if B prevails over A, then B should be able to enjoy the privileges that come with prevailing, and that is the ability to sell property, and therefore C should be able to rely on B's rights. One of the advantages of a notice statute compared to a race statute is that it avoids the problems of bad faith purchasers being protected by the law. Of course, once you introduce the conception of notice and making that relevant to who is going to prevail, we do introduce questions of whether that notice exists or not, opening the door to all kinds of evidentiary disputes. The final kind of statute we're going to talk about in this video is a so-called race notice statute. And under a race notice statute, a subsequent purchaser is protected against prior unrecorded interests only if, 1, the purchaser does not have notice of the prior instrument, and 2, the purchaser records first. So let's imagine O conveys to A, who does not record. O then conveys to B, who does not know about A's deed. A then records, then B records. What result? And so, under a race notice statute, A would win. A is first in time, so who needs the statute to be protected? B is the party who needs the statute. And to be protected by a race notice statute, B needs to be a good faith purchaser without notice, check, who also records first. No, B fails that condition, and therefore A prevails. The only way to get comfortable with the recording statutes is to work out some problems. And so we'll have a couple in this video, and you can hit pause as need be to think about your answers. A lot of these problems are basically going to focus on the idea of a grantor who gives to one person and then conveys to another person, then conveys to another person, in almost a way that kind of looks like, a weird sort of fraud. And that's kind of the norm for the law school hypothetical, right? We're imagining someone who sells land to multiple people, and that may seem unrealistic. But in real life, recording acts may resolve all sorts of questions about the priority of interests of land that may be acquired after prior unrecorded interests. So they may resolve questions like whether an easement survives a sale of the underlying land, or which bank's mortgage has priority in reaching the proceeds of a foreclosure sale. But for simplicity, these problems are just going to use the hypothetical of repeated sales of the same piece of land. So let's start. Suppose O conveys to A, who does not record. O then conveys to B, who purchases in good faith for valuable consideration, but does not record. A then records and conveys to C. C purchases in good faith for valuable consideration. B then records, C then records. Who prevails under a notice statute? And the answer is C. C prevails over B because C is a subsequent bona fide purchaser from the record owner, A. The notice statute protects C from B's interest, which was unrecorded at the time of C's purchase, so there was no way for C to find it by looking at the title records. Note, of course, that B would have prevailed over A as a bona fide purchaser. Likewise, if B had recorded before A had conveyed to C, C would have been on notice of B's interest, and there would have been no way for C to defeat B's interest using the recording statute. So to clarify one point, does it matter that A recorded for C to have prevailed? Not for C to prevail over B, but we do need to acknowledge a potential argument that maybe a court might say that the incomplete chain of title should have put C on notice that there might have been a problem that C should have investigated. Let's imagine the same facts as before, but what if now we're in a race notice jurisdiction? So O conveys to A, who does not record. O then conveys to B, who purchases in good faith for valuable consideration, but does not record. A then records and conveys to C. C purchases in good faith for valuable consideration. B records, C records. Who wins under a race notice statute? And the answer is C. A prevails over B because A recorded first. C then takes from A. And this would be the same result even if C had notice of B's claim. A is first in time over B, so B needs the statute in order to take over A. That means that B needs to record first, but A records first. C then takes from A. So it doesn't matter if C had notice of B's claim because B already loses against A, and therefore to recognize A's rights, A needs to have the ability to convey to C. So I alluded to this before, but note that there are multiple ways of thinking about notice. There's actual notice. Somebody just literally knows about facts on the ground. There's record notice. You can find out about earlier interests by looking at the title records. And there's inquiry notice. Facts on the ground that should make you aware that you need to investigate a little bit more to know whether or not there is a prior unrecorded interest in the land in question. So imagine these facts. O conveys to A, who does not record, but assumes residency on the property. O then conveys to B. Now, B doesn't have record notice, but we would naturally expect someone who is thinking about a land purchase to actually check out the land, and the fact of A living on the property would put a reasonable person on alert that O perhaps does not have good title to convey in that situation. Final point that I want to cover in this video is about the question of donees. So typically donees are not protected by the recording statute, and the general fact that donees are unprotected creates some problems that are worth considering. So let's just imagine the very basic situation. Suppose O conveys to A, O then gifts to B, who has no notice. B records, A records. And so what happens in either a race notice or a notice jurisdiction? And the answer is A prevails in either jurisdiction. So why is that? To overcome first in time, first in right, B needs the statute. And as a donee, B does not have protection under the statute. But it's important not to overread this principle, as the next two problems are going to illustrate. So suppose these facts. O gifts land to A, who records the deed. O conveys to B for valuable consideration. B records. Who wins? And the answer is A wins, even though A is a donee. Why is that? B has no protection, whether it's a notice or a race notice statute, because B has record notice of A's rights. A recorded. So note that even though A is not protected by the recording statutes directly, the recording statutes still give A every incentive to record as soon as possible. But A is not the one seeking protection under the Recording Act, and therefore A's status as a donee doesn't matter. So if that's still not clear, just break it into steps. Who is first in time? It's A, and therefore who needs the Recording Act? The party who needs the Recording Act is B. What does B need to be protected? Under either a notice or a race notice statute, B needs to be free of notice of a prior competing interest, but B, of course, has notice because A recorded. Last one. Suppose O gifts to A who does not record. O then conveys to B a bona fide purchaser without notice. A records, B records, and here imagine that we are in a race notice jurisdiction. Who prevails? And the answer is A wins. To have protection of the statute, B has to be a bona fide purchaser and B has to record first. If B doesn't meet both those conditions, the background rule of first in time, first in right prevails, and A is first in time, first in right, therefore A wins, notwithstanding the fact that A is a donee. Thanks for listening.